So, bonjour tout le monde, hello everyone. Je suis très heureux de vous accueillir aujourd'hui cet après-midi pour ce premier atelier virtuel du CDTS. I am delighted to welcome you today for our first virtual workshop. For those who don't know me, my name is Florian Martin Barito. I am an associate professor of law and the director of the University of Ottawa Center for Law, Technology, and Society. For today's virtual workshop, we are welcoming three amazing Canadian scholars. The first one being Carys Craig, an associate professor of law at Osgoode Law School. Jeremy De Beer, a full professor of law at the University of Ottawa and a CLTS faculty member, and Paul Daly, the University Research Chair in Administrative Law and Governance at the University of Ottawa. And today's workshop, the topic is the recent Federal Court of Appeal decision in ESA versus Society Composers. And they will discuss the making available right. Without further ado, I will give the floor to Paul Daly that will moderate the conversation. And again, if you have a question, I will invite you to ask them in the conversation. And Professor Daly will feed the panelists with your questions. So Paul, Carys, Jeremy, I think you're the three of you all here. So I will switch off my own camera and I will give you. Thank you so much.
Merci Florian pour cette introduction. Thanks very much, Florian, for getting us started and also for setting up this platform with your expertise and that of your team. As you mentioned, we're going to be talking about the making available right, particularly focusing on ESA and Society of Composers 2020 FCA 100. There's a companion case as well, Simra Sadrak and Apple. 2020 FCA 101, which we might mention as well, but the primary focus is going to be on the discussion of the making available right in the first case, 2020 FCA 100. So Professor Craig, Professor De Beer, good to see you. So Carys, if I'd ask you first of all to give us a bit of a primer on what the making available right is or would be as a conceptual matter, and what's the statutory framework in which the Copyright Board considered whether such a right should be recognized in Canadian law and in what form.
Great. Okay, thank you. Can you hear me okay?
Loud and clear.
Perfect. All right, so first of all, thank you to the organisers and thank you, Paul, for the invitation to be here today to talk about this. So if the question is what is the making available right, then the answer is it depends who you're asking. I'll tell you what I think it is, and I'll give you a sense as well of sort of the international context and the domestic statutory context for understanding it. But what it is exactly is, of course, a matter of debate, which is why we're here. So the making available right is really a creature of the 1996 Internet Treaties that came from WIPO at a time when there was a great deal of anxiety around the move towards online commerce and the existence of the internet. So we're going back to the mid to late 1990s when there was a great deal of concern that maybe the internet was going to render redundant the copyright system as we knew it. And there was kind of a preemptive mobilization of parties to try to ensure that the kinds of transactions that might now be happening in an online environment could be caught by the copyright system as it had been developed internationally. And so in particular, there was a sense that there might be a gap in existing rights as required by the international copyright scheme when it comes to the kinds of technologies where, rather than having a party just send out, for example, a broadcast to the audience at one time, that they would make something available online and audience members or consumers could come along and watch it when they chose to watch it. And so this is a distinction really between push technologies and pull technologies, and the sort of responsibilization of end users to pull content towards them created some anxiety amongst content industries that might not be covered. So long story short, and we might come back to think a little bit more about the lawmaking process here, but the WIPO Internet Treaties included, let's take the WIPO Copyright Treaty in Article 8, a provision that said, with respect to the right of communication, which was an established copyright interest of authors, the author shall enjoy the exclusive right of authorizing any communication to the public of their works, including the making available of their works in such a place that the public might access them from a place and at a time individually chosen by them. Okay, so that was really it. And then in the Canadian context, we actually took, so that was 96. In 2002, those treaties came into force, and in Canada, it took us until 2012 with the Copyright Modernisation Act to really follow through and implement some of our obligations under those treaties. And one of those provisions that was added in 2012 was a definition of the right of making available. And what we ended up doing with the 2012 amendments is adding in section 2.4, 1.1, a definition of communication to the public to say that for the purposes of this act, I'll just read it out, it includes, communication to the public by telecommunication includes making it available to the public by telecommunication in a way that allows members of the public to have access to it from a place and at a time individually chosen by that member of the public. Okay, so that's really the international context, that's the statutory scheme. And then the question that we're going to be grappling with today, and that the courts and the Copyright Board have been grappling with, is the relationship between that making available right and the right of communication to the public and the right of public performance more broadly.
Right. Thank you very much for that, Carys. Just one thing before you mute yourself is why does it take so long for these international agreements to filter into legislative action? Is this a Canadian phenomenon, or are other jurisdictions similarly lax?
That was, again, it kind of depends who you ask. I think there were lots of good reasons why Canada was slow to move and why it took until 2012 to do so. Many other jurisdictions around the world also waited a long time. Some of them still haven't quite got around to it. And others, of course, were very quick off the mark because really it was in their interest and they had sort of led the movement to get these treaties concluded. So in large part, it depends where you stand on it and what you have to gain from it. And then ultimately ends up being, I think, a matter of international sort of diplomacy and economic trade considerations. Eventually, I think Canada was under pressure to really move and make good on its commitments, particularly with respect to its trade relations with the US. But there were 3 failed bills before 2012, so there were actually multiple attempts to pass legislation that would so-called modernize the Copyright Act, and it was highly controversial at each iteration. The bills failed when governments changed, and so it was a long process to get to 2012.
All right, thank you for that, Jeremy. So in these 2 cases, so we're FCA 100 and FCA 101, Entertainment Software Association and SIMRA SODRAC. What exactly was that issue? What had the board been asked to do? What was going on before these cases ended up in the Federal Court of Appeal?
Well, the companion cases have one of the issues was a legal issue and the other was primarily an economic or a rate setting issue. And so that's why the applications for judicial review were split into, and the decisions split into these two companions. One deals with the legal question, the 100, and the other deals with the economic question, the 101. But to really understand what's happening in these two Federal Court of Appeal decisions, you have to look at this within the much longer saga of the Copyright Board's efforts to deal with really challenging issues of copyright on the internet. We are now going on almost a quarter century since SOCAN initially proposed a tariff for the communication of music online. And that has gone to the Supreme Court twice, and possibly in this next iteration, a third time. And the board in that context had, in my view, quite a difficult task, because it was grappling with not only the legislative changes that had been brought about by implementing the treaties that Professor Craig talked about, but also a series of Supreme Court decisions on copyright and interpreting the communication right, interpreting the reproduction right, and changes in administrative law in terms of the scrutiny to which its decisions would be put. And it's in that context that that the board released a decision in 2017 which contains extremely detailed legal analysis, pages and pages and pages of legal analysis on what precisely the making available right is and what its implications are for not only SOCAN, the collecting society that administers performing rights in Canada, but also other collecting societies that administer reproduction rights and a wide range of users. And so what the board was really trying to do in its decision was come up with I would say a comprehensive and coherent view of how all of these different rights fit together in the context of controversial and split decisions of the Supreme Court and legislation that had been the culmination of almost a decade of efforts to implement the WIPO Internet Treaties. So that's the main decision, the FCA 2020 FCA 100. That's the legal decision. At the same time, there's a question of, well, assuming there is a making available right and that SOCAN is entitled to collect royalties for it, or other collectives are entitled to collect royalties, what should the rate be? And in that context, the board also issued a decision of nearly 120 pages, going through extensive expert evidence, economic evidence, and at the end of the day, held that there was insufficient economic evidence to reliably set a rate, what the rate should be. And so those two decisions, in the legal decision, the Federal Court of Appeal overturned the board's decision, finding that the board's legal interpretation was unreasonable. And in the economic decision, this FCA 101, the Federal Court of Appeal upheld the board's decision as reasonable. So the board overturned the legal decision, the court, pardon me, overturned the legal decision and upheld the economic decision.
Well, thank you, Jeremy. And we'll come back to that, the different levels of deference that the Copyright Board managed to get, or seems to have managed to have got from the Federal Court of Appeal in respect of the two different decisions. Carys, before I come back to you, can I try and, in my layman's terms, or at least my administrative lawyer's terms, try to understand what exactly the making available right might mean in practice. So as I understand it, when I download or stream something off the internet, there's clearly I'm using copyrighted work in instance. I'm consuming it and I'm enjoying it. But the suggestion here was that there's something that happens prior to that, which is that the very act of making that product available on a server, let's say server to keep it simple, that making available of the product is itself an act which engages copyright and which creators should be compensated for. Now I have to say, again with my layman's hat on, that makes good sense to me. I can see how Rogers or Bell or other entities which make material available on their servers can benefit from having the material available. And me as a consumer, I'm drawn to platforms which have lots of content on them. So there's something of value to Rogers and Bell and other entities to having this these products there. So am I right about that with my layperson's hat on, or am I oversimplifying it? And then in responding to that, you might like to comment on why the Copyright Board's approach here was problematic, particularly in light of the way the Supreme Court has interpreted the Copyright Act and has relied on the principle of technological neutrality and other structural or purpose-based principles to delineate the scope of copyright.
Okay. So no, I think you're wrong. I think you might be wrong about that. But it's not to say that there's not some. Maybe it's actually the assumptions that the question is built upon that I want to tackle a little bit. So you're saying, just to be able to see the catalog of things that are available to you as a user, that has an economic value, or it gives an economic benefit to the provider, and therefore it makes sense to you that should be able to be captured, that economic value. And so I suppose I would come in and say, I would just be resistant to begin with to the idea that any potential economic benefit that might be enjoyed by somebody should be captured by the copyright owner and internalized by them. There might be some positive externalities and some economic value to be enjoyed. It doesn't necessarily follow that should always flow inevitably and necessarily to the copyright owner. But I think what the real danger is in approaching the question in that way is that you end up with a sort of proliferation of rights and right claims that are overlapping and duplicative and that apply to a single kind of activity or a single transaction. So if we think about the simple making available as the proprietary act where you say this is available for the consumer, and that triggers already the making available right. And then you separate off the value of that to be assessed and to be attributed royalty rates. And then you have the transaction of the actual streaming, the thing that the consumer is actually paying for that gives them the value that they want. And then you assess that for a separate royalty rate. And then you layer on the idea that there's been a copy and digital copies made in the process, potentially at both ends, if a download has been made by the consumer and there's the upload by the distributor. And then you've got to allocate funds to pay for the royalties in relation to those activities as well. And you can see how this ends up looking like a kind of rent-seeking game where everybody who thinks they could extract some kind of value gets to line up and get their piece of the pie. And meanwhile, the system becomes both overly complex and overly expensive, and it becomes sort of an obstruction to our enjoyment and our use of the digital technology. So I think that concern with double dipping by the copyright collectives to get extra royalties for each act, and the layering of rights, and the fact that there's going to be additional money to be paid because of the nature of the technological processes at play. These are the concerns that motivated the Supreme Court in 2012 to refuse to grant SOCAN what it wanted in respect of the sale of download copies of video games that contain musical works. So in 2012, the Supreme Court in the ESA decision was really very clear, although I take Jeremy's point that it was a split court and it was a narrow majority, but they were really quite clear that with a view to ensuring sort of the fairness and the usability of the technology, to prevent this double dipping, to prevent a sort of tax on internet technologies, that we ought not to allow this multiplication of rights in respect of a single activity. And so the primary concern I had with the board's ruling now is that nothing has changed from 2012 to 2020 in terms of the concerns that animated that Supreme Court ruling. And yet the board gave short shrift, if any, to the sort of motivating factors behind the Supreme Court's decision in ESA.
All right, thank you. That's all very clear. I think I know a little bit about copyright law, and indeed one of the things you first begin to understand when you encounter this area of the law is what seems like something which might be very simple. Copyright is actually fiendishly complex, both ontologically, as it were, and also organizationally, because it's of the way it's administered, particularly here in Canada. Many players involved. You mentioned the ESA decision in 2012, and that the neutral site for that is 2012 SCC 34 ESA and SOCAN. You'll note if you read that closely that Professor Craig is cited for one of the key principles underpinning the Supreme Court's decision in that case. Jeremy, we now have a pretty good picture of the lay of the land here, the history of the statutory backdrop and the Supreme Court's key interventions in this area. And the next issue is, was the Copyright Board's decision unreasonable? Because we're now in a cycle of administrative law, as you mentioned earlier. There have been many cycles of in Canadian administrative law. We're now into another one, and the standard of review is presumptively reasonableness. Justice Stratus, who wrote the two sets of reasons for the Federal Court of Appeal, has some doubts about whether reasonableness will be the standard going forward, and we'll come back to that issue later. In this case, they applied the reasonableness standard. And as we know, the reasonableness standard recently got an overhaul from the Supreme Court of Canada in the Vavilov decision, which was released just before the holidays in December of last year. And in order for the Federal Court of Appeal to intervene and say that the Copyright Board had erred, the Federal Court of Appeal had to demonstrate that the decision was unreasonable. So in that context, Jeremy, what was it that was, in the Federal Court of Appeal's view, unreasonable about the Copyright Board's approach?
Well, Professor Craig has already alluded to one of those points, which is unacceptable legislative interpretation. Justice Stratus faulted the board for failing to essentially follow through on the principle that the board identified as the guiding principle, the modern rule of statutory interpretation. The board mentioned that rule, but then failed to mention what Justice Stratus called important elements, particularly contextual elements, such as the 2012 ESA decision. And so it was in that process of the exercise of legislative interpretation that the board made these unsupported leaps of reasoning that the Federal Court of Appeal felt couldn't be justified. The second broad criticism of the federal court, the Court of Appeal rather, that made the board's decision unreasonable was a mistaken understanding about the relationship between international law and domestic law. So if I could just circle back and cover those very briefly. On the unacceptable legislative interpretation, I think the key issue that the board failed to grapple with was the contextual element of what Professor Craig called the double dipping. I've published a chapter in Professor Geist's book where I called this phenomenon royalty stacking. It's been called layering. But the problem is the same. It's the tendency to try to extract a share of value whenever there's value to be realized. So I guess to add to Professor Craig's response to your question about isn't there value in having the catalog, you can see that two ways. There's also incredible value to the copyright owner of being on the shelf. And in many contexts, both digitally and in bricks and mortar retail, there's a payment of some sort for that shelf space. And so to say that that the retailer, whether it's a digital retailer or a bricks and mortar retailer, ought to be paying for the privilege of stocking inventory, I think is problematic reasoning. So the Court of Appeal didn't actually get into that. Rather, Justice Stratus cited this problem with double dipping or layering, and the board's failure to consider those aspects of the Supreme Court's jurisprudence in ESA and subsequent cases like CMRA and Sodrak, where that's a real issue. What I found particularly interesting about that part of the Court of Appeal's reasons is the relationship between what Justice Stratus called in paragraph 50 contextual elements and the Court of Appeal's clear guidance on avoiding policy-oriented reasons or policy outcomes. And so the Court of Appeal is very clear that this is an exercise in what is essentially textualism, and that there isn't a role for proactively considering policy reasons or policy rationales, but then nonetheless cited the failure to consider those contextual elements as one of the shortcomings in the board's reasons. The second ground of criticism, the misapprehension of the relationship between international and domestic law, is in my view, very welcome guidance from the Court of Appeal. We have seen in many areas of law, but copyright is I guess my field, so I'm particularly familiar with the problems it causes. This appeal to international law as a scare tactic, essentially, to try to coerce courts to reach some decision for fear of being offside of international law. And Justice Stratus, I think, very helpfully said that's not the way it works, right? So if a court interprets legislation in the way it should, and the result is that there's a gap in protection or non-compliance with a treaty, well, that's not the court's problem. That's Parliament's problem. And I think that was the core of the concern. Justice Stratus was very critical of the board's wrong turn, I guess, where after citing the proper principle of statutory interpretation and paying some lip service to the preamble to the Copyright Modernization Act and the history of 2.4, 1.1, spent, I tried to count it this morning, I lost track, it was over 20 pages of space talking about international law. And the real difficulty with that aspect of the board's decision was that it failed to appreciate how controversial and ambiguous international law itself was. So there were 5 different expert opinions submitted to the board, and full disclosure, mine was one of those. So I'm not speaking as an impartial observer here, with different views about what the treaties actually require. Now, former ADG of WIPO, Mihaly Fichor, and numerous other experts all agreed that there was no one particular way that these international treaties had to be implemented in domestic law. Dr. Fischor called this the umbrella solution negotiated at the international level. So everybody agrees that there's more than one way to do this. And the question is, well, which way did Canada choose? The board, in my view, problematically chose its preferred opinion on the basis of speculation about what other interpretations of those treaties would mean. So in my own opinion submitted to the board, I suggested that Canada could comply with its Internet Treaty obligations using a collage, a patchwork of different rights. In some circumstances, it would be the communication right. In some circumstances, the reproduction right, possibly the publication right or the distribution right or the authorization right. And the board went through all of these scenarios about how Canada could achieve treaty compliance, saying, well, this isn't perfect because you might have this potential hypothetical problem with the reproduction right. And this isn't perfect because there's a hypothetical problem with the authorization right. And in my view, the problem is that failed to account for the possibility that subsequent decisions interpreting the reproduction right or the authorization right could take account of what the board would do with the 2.4.1.1 and the making available right, and then later interpret those other provisions if necessary to fill any gaps. And what the board tried to do was essentially come up with a comprehensive and rather grandiose theory of digital copyright in Canada. And I think that was just too tall an order. The issues are just so complicated, and there are so many uncertainties and unknowns that in dozens of paragraphs of what would ordinarily be obiter dicta to try to interpret how Canada implemented these treaties, there's just so many different layers of uncertainty there that I think Justice Stratis was justified in saying that the board was led astray, that its decision in that respect was unreasonable. In essence, in my view, what happened was the board tried to do too much. Because if I could just speak in defense of the board actually on this, I know the board has many critics. I'm not one of them, having been former legal counsel at the board, and as if you've read my writing and some of my analysis, studied the challenges that the board faces in implementing these decisions typically for the first time, in implementing these legislative provisions typically for the first time. I think really the board tried to paint a very clear picture that would solve all of the unanswered questions and leave no stone unturned. And in doing so, perhaps said too much or tried to say too much.
The picture you've painted there, Jeremy, is of a decision-making environment in which the board operates, which is suffused by policy considerations, which is dynamic, which lies at the intersection between domestic law and international law. And Professor Craig has also provided more background to demonstrate just how interesting and intertwined all of the issues here are. It seems to me, reading the board's decision, that not much of that comes across. The board, as you say, develops this grand theory, but it is placed on what seems to me to be a pretty thin reed in section 2.41.1 of the Copyright Act. And I think in a sense, the board might have been on a hiding to nothing in trying to do an analysis based on text, context, and statutory purpose on a major question of law. The Federal Court of Appeal is bound to feel, whatever the black letter administrative law doctrine says, the Federal Court of Appeal is bound to think that it's as well placed as the Copyright Board to engage in this interpretive exercise. So I think what struck me on reading the board's decision was that it didn't grapple as much as it might have with the nature of the policy issues, the fact that it might have a different view of Supreme Court precedent, the fact that it might have a heterodox approach to international law. There's a lot of space in Vavilov, and of course the Copyright Board didn't have the benefit of Vavilov before writing its reasons here, but there's a lot of flex in Vavilov to allow decision makers to take account of general principles and turn them to their own ends. But the Copyright Board, I suspect here, might have taken too narrow a view of its remit, and that's part of the reason it ended up getting into trouble. But anyway,
but Paul, isn't that, I mean, that's the paradox, right? That by attempting to create an incredibly detailed, doctrinally grounded ruling, as opposed to taking its own view of the policy issues or citing the policy considerations, that's the very thing that got the board into trouble. And the irony here is there is probably no group of people more expert on the legal minutiae in this particular field than the legal staff at the Copyright Board of Canada. Especially in the context of interpreting this particular piece of legislation. And so by bringing in that incredible depth of expertise, that's essentially what sunk them in my view, which is that this is the paradox or the irony of this decision.
I agree there's a paradox there. I think Vavilov says that expertise has to be demonstrated when it comes to reasonableness review, and I think the challenge for a decision maker like the board going forward is to demonstrate how exactly it brings its expertise to bear. But you're right, there is quite a paradox at the very least in seeing the board, which has unique access to what was going on in the international arena, what was going on in the minds of the legislative drafters who actually wrote the legislation in 2012. The Copyright Board and its staff were in a privileged position to know what Parliament intended, and it's a significant challenge to demonstrate that particular expertise and subject matter understanding. Professor Craig, back to you. Now, two kind of follow-up questions on the consequences of these Federal Court of Appeal decisions. One, is Canada now out of line with its international law obligations? Did this contribute to our failure to win a non-permanent seat at the Security Council? Is it that serious? Is it that bad? And secondly, will this case go to the Supreme Court of Canada? And if it does, what is the Supreme Court of Canada, in your view, likely to say?
All right, well, thank you. And thanks as well for, I think the discussion you both just had about the Copyright Board decision was very informative. I learned a lot, but I'm also not quite as generous in my reading of what the board did in the first instance, I have to say. So it's interesting to think through the challenge that the board had on its plate and how it chose to address it. But I think I'm certainly in agreement with Justice Stratis in the Federal Court of Appeal in saying that initial reliance upon a particular interpretation of a very controversial and ambiguous international law provision in order to then essentially deem a provision of the Canadian Act to say something that it expressly does not say, to me that it was kind of a tortuous interpretation of 2.4.1.1, which from the very beginning, I think, was informed by a misunderstanding of Canada's international obligations under the Copyright Treaty. So just quickly on that, and the question was, is Canada now out of line with its international obligations? And I glanced down at my notes here and I see that they say no. So no, it is not. Not super helpful, but you know, I remember when we were debating this and going through those various bills on our way to 2012, and you know, there was actually a lot of support for the position that Canada needed to do absolutely nothing in order to implement the making available right. That once you looked at the rights that we have in the Copyright Act already, once you take into account the reproduction right and the communication right, and the fact that we have as a separate right the right to authorize communication and the right to authorize reproduction, we have already more than covered the ground that Article 8 of the Copyright Treaty was intended to cover. And so I think my recollection is that was the sort of baseline assumption. And then, and certainly I think that's been the US approach to say, don't worry, we already take care of this through other means. And then when it came to it, for clarity's sake, we wanted to include something that said, oh, and these rights, to be clear, that we already have, include that thing you want to make sure that we include, right? And so when you read 2.41.1, the right includes making available to the public. It couldn't be clearer. And you really do have to go the wrong way around through international law and a particular controversial interpretation of the making available right as a freestanding right to get to a basis on which to interpret that provision in any other way. So I don't even think it's a matter of statutory interpretation so much, or even the approach that a decision maker should take. Because if you take a textual approach, the text is clear on its face. If you take a policy-driven normative approach, the policy for why the text says this, as the Supreme Court has explained, is also very clear. So there's really just, to my mind, no good way to get to an alternative reading on the basis of either our policy and our objectives or an interpretation of the statutory text. So anyway, in answer to your question, no, I think we already more than cover making available, and you can do that. It was designed and it was only agreed to internationally precisely because you can protect the right to make available through the usual sort of catalogue of rights that already exist in Canada's copyright law. And I think our Supreme Court has been very good at trying to rein in what I think internationally we could reasonably call the proliferation of copyright, to try to capture every sort of new technology and every new opportunity to exploit. And the Supreme Court instead clearly said, you know, we have three central rights: the right of reproduction, the right of public performance, and the right of first publication. And all of these other illustrative rights are just that. They're examples of how these three rights might be infringed. And in doing that, they said everything else belongs within this chapeau of copyright interests, and it can't just continue to expand in new technological contexts. So we clearly cover making available. We have done everything we need to do in that respect, and I think we ought not to be worried about that. I think it's a red herring in this context. I think it might be worth, and perhaps this is something we can come back to, but maybe in the copyright context, there's something relatively not unique, but specific about the way that we understand the role of international law. And I can understand if you come from a different field, you might think of international law as being that sort of make weight factor that the Federal Court of Appeal referred to, that it has some sort of normative heft that should constrain domestic lawmakers and domestic decision makers. And I think it's not unreasonable for me to suggest that international copyright law doesn't really have that same principled normative heft, that there's a sense that it has evolved in response to content industry demands, international trade pressures, in ways that sometimes conflict with the actual underlying objectives and policies at stake in domestic copyright regimes. And so I really think in this context, we should be careful with what we do with international law when we think of it as sort of a principled regime to which we should defer. I would caution against that. As for whether it's going to the Supreme Court, I don't know if you know something I don't know. I would imagine it will certainly be appealed. I'm not sure if the Supreme Court would agree to hear it. I would hope not. And then I would suggest that hopefully, if this goes to the Supreme Court and the arguments get made there, I would really like to see the Supreme Court do what it did in those 2012 pentology cases with respect to Tabers and CCH, and looking back and saying, you know what, we've already actually told you what we think about this, and we meant what we said, and we would like you to actually continue to listen to it, and so maybe repeating what was said in ESA and hopefully doubling down a little bit on the importance of that principle of technological neutrality.
Yeah, there's perhaps a question as to whether Vavilov gives the Copyright Board a little bit more room to tackle those Supreme Court precedents head on, but they would have to do it, and obviously they didn't have the benefit of Vavilov here. And Justice Stratis, as a remedy, didn't remit the matter to the board. Said the board's decision is unreasonable, and pretty much left it at that. In any event, in the companion case, there was insufficient evidence to support the making of a tariff. So we're kind of I wouldn't say in no person's land, but the Copyright Board, if it does go to the Supreme Court, it's going to be a review of the Copyright Board's 2017 decision, which was pre-Vavilov, and which doesn't. I think the essence of our discussion today is that it's not really a decision where the Copyright Board tackles head-on what it might see as problematic aspects of the Supreme Court's copyright jurisprudence. Just one more question for you on this, Professor Craig, though. What does Section 2.4 1.1 mean? So again, on remedy, Justice Stratis says, look, I'm not going to give you a declaration as to what it means. I think, understandably, it's reasonableness review. All the court's role is to say that the Copyright Board was reasonable or unreasonable. It's not appropriate for a court to use the opportunity to make a general declaration as to what the law is. But what does it mean in the interim? Well, what does Section 2.4 1.1 mean? And what did Parliament accomplish in 2012 when it added this provision to the Copyright Act?
Yeah, so I think the main question well, from what I've said, we can safely limit it to applying only to communications to the public, that is to sort of public performances or performance-like transactions as opposed to sales of digital copies. So we can say what it doesn't mean, which is the making available of something for download or for sale of a copy. That still leaves us with a question about what it means with regard to communications to the public and public performances, and making available for that purpose. And the big question really is, first of all, when the right is triggered, and then whether it is triggered twice, so the first act of the making available and then the communication to the public. And so to my mind, I think if 2.4 1.1 achieved anything, what it achieved was making sure that the initial making available of something for streaming, for public performance, would trigger the communication right. I think it probably already would trigger a right, because it would be or could be taken to be an authorization of a communication. So I don't even know if that was novel, but I think that much is clear. And I also, for my own part, the next question is, well, what if nobody ever actually streams that thing? What if nobody ever watches it? Can it really still be called a communication to the public if it was only ever made available but never accessed? And, you know, right now, I think that's maybe more of an intellectual question or exercise than anything else. But my answer would be, maybe it doesn't need to be completed in order for the communication right to be triggered by virtue of 2.4 1.1. That's as far as I could go in saying that it added something new to the law. Certainly what I would say is it cannot mean that two rights are triggered when something is made available and then streamed. That initial making available, even if that's what triggers the right, is part of the communication that is ultimately completed when the consumer accesses that content.
All right, thank you very much. Professor De Beer, one last question for you before we throw it open to Q&A. And by the way, if you're sitting there riveted, obviously, by this fascinating discussion, you can type your questions into the chat box, and I'll distribute them to Professors Craig and De Beer for your further enlightenment. Jeremy, what's the standard of review going to be of Copyright Board decisions in the future? Justice Stratus applies reasonableness review here, but he suggests, we all remember one of the, those of us who like administrative law remember that in the Pentalogy in 2012, in the Rogers case, Justice Rothstein managed to justify the application of the correctness standard on the basis that copyright issues can come up in the federal court in first instance in actions, and they can also come up in the Federal Court of Appeal reviewing the Copyright Board. So a question about Section 2.4 1.1 could come up before the federal court, could also come up before the Copyright Board, and then before the Federal Court of Appeal. And Justice Rothstein said that in the interests of coherence, we ought to have the same standard in both contexts. So correctness review on decisions, questions of law determined by the Copyright Board. Vavilov says that reasonableness is the presumptive standard of review in all cases, subject to some limited exceptions. Vavilov says nothing, though, about Rogers. So it's going to be up to the Federal Court of Appeal in some future case to tell us what the standard of review is. So, Jeremy, what's the answer?
I don't know if I'm the best person to answer that. In fact, I know that I'm not. You are, but I will make two relevant observations. The first is that Justice Rothstein's comments echoed what his then colleague on the Federal Court of Appeal, Justice John Evans, had written in 2002 at the Federal Court of Appeal in Spokane and Cape. So it was before Spokane and Cape went to the Supreme Court of Canada that Justice Evans had actually, and as we know, a renowned expert in administrative law, had actually made that point about the overlapping jurisdiction and the need for doctrinal coherence. And so I think I thought that Justice Evans was right then. I thought that Justice Rothstein was right later, and I think that continues to be a really important matter of principle. I don't know if it's important enough to nuance what the Supreme Court did in December of 2019. The other comment or observation I would make is that I think Justice Stratus in the Federal Court of Appeal in this particular case did an excellent job of ensuring that if this goes to the Supreme Court, it will not go to the Supreme Court on the question of standard of review, which is a welcome development in my view. So by essentially saying, we don't have to settle what the standard of review of the board is right now. Let's assume it's the most deferential and proceed on that basis. I think that the Court of Appeal's reasons here, in essence, insulated this from an application for leave to appeal on the grounds of standard of review. Now, the interesting question that this leaves me to pose, I guess, to you, Professor Daly, is Justice Stratus's application of the reasonableness standard in this case the same as or different than Justice Abella's application of the reasonableness standard to copyright board decisions in Rogers and SOCAN, in Alberta and Access Copyright on similar issues about the test for fair dealing or the application of different rights or the relationship between them?
Well, I think you're right that Justice Abella's approach in those cases did resemble de novo review of the issues before the Copyright Board. They bear the hallmark of what administrative lawyers call disguised correctness review, which is that there's very little mention or engagement with the decision maker's reasons, but rather an independent analysis of what the outcome ought to be. I don't think Justice Stratus, apart from the primer on international law 101, which, and as you've already discussed in the copyright, in the intellectual property field, that might have served as a helpful reminder. And I'm sure there are other areas too where the federal courts hear argument which raises international law, but perhaps not in a particularly doctrinally rigorous way. With the exception of that sort of primer on international law, I think, to be fair, Justice Stratus engages with the reasons and starts with the reasons and says, look, what the board did here was it looked a little bit at the text of the statute. It looked a little bit at the run up to the enactment of that provision, and it mentioned ESA, but really it didn't grapple with what the text means, what it means in the broader context, the richer context that the two of you have laid out. That this is being this decision is nested in a variety of rights of different natures, and it has to be reconciled with those. And so I don't think I would say that Justice Stratus was engaged in disguised correctness review here. And ultimately, Justice Stratus is saying the board did not go through the text, context, and purpose analysis that it promised. It went too quickly, too fast to international law to try and resolve the disagreement or to resolve the question, and ultimately it failed the reasonableness standard on that basis. But I will say that I think if the board had had the benefit of Vavilov before producing these reasons, we might have seen something different. I see that questions have come in, and the first question, I think we said that we'd leave the questioners anonymous. Sorry, questioners, if I'm giving you anonymity that you don't want. The first question is directly on point. Should this have been dealt with at a very early stage by a simple reference to the Federal Court of Appeal under Rule 320 of the Federal Court rules? Jeremy, could the Copyright Board have dealt with this essentially by just flipping the puck to the Federal Court of Appeal at an early stage and avoided us the lengthy board process leading up to 2017 and the many intervening years since 2017 where we've had the judicial review applications? Was there a quicker way to deal with this?
I think the simple answer is yes.
And it is, I would add that administrative tribunals don't very often take advantage of their ability to state cases to the courts, and sometimes on broad questions of law. There might be a case doing so. It's interesting again to note the difference between the 2020 FCA 100 and 2020 FCA 101 in terms of the Federal Court of Appeals approach. That question was from Howard Knopf, by the way. He has waived any anonymity that he might have had. But big difference between the tariff setting, where Justice Strata says there's a policy element to rate setting, and the approach to the legal question. Next question. In 1979, the Federal Court of Appeal held that the sole function of the board is to fix the rates which the performing rights societies can charge. While the societies must still establish their legal right to collect the tariff, if a user contests that right, then the courts are the proper forum for the determination of the rights of the respective parties, not the board. That's Posen from 1979. Later, the FCA stated that the board does have jurisdiction to hear incidental questions of law when it's necessary and inexorably linked to the exercise of its rate-setting function. But the FCA also emphasized the ad hoc nature of such determinations. And the questioner goes on to observe, as the two of you have done, that in this case, the board tried to do much more than that, nothing ad hoc or incidental to the rate-setting process about the board's interpretive exercise here. I think that's fair to say. And the questioner asks, does the outcome justify an approach that the courts, not the board, are the proper institutions to determine substantive questions of copyright liability? Professor Craig, I know administrative law is not your thing because you're a normal professor and not quite rightly not interested in the arcane details of standard of review. But do you have a view on this? I mean, this is there's an important question here about what sort of mechanisms we use to resolve copyright disputes. We mentioned earlier in the discussion that in bricks and mortar retail, people often or businesses often pay for product placement. One way or another, they pay for product placement. We don't have a product placement board which regulates this. We leave it to the invisible hand of the market, as long as it's not eggs and milk, where things are different in Canada. But what would you say about the Copyright Board and what it's doing, and whether the Copyright Board is the best place to resolve questions of law about the scope of copyright?
Well, thanks. No, administrative law is not my cup of tea. I cannot lie. Mostly it's because I always think at the end of the day, correctness and reasonableness end up being much the same thing. So to the extent that it forces me to have a long conversation about which is the right standard, I can never quite see the point. Seems to me, especially I think in trademark and copyright, at least, because these are the cases I know, as soon as someone thinks a decision is incorrect or wrong, they also think it's unreasonable. And they can go from there. So, but anyway, in terms of the role of the board, this is another thing where I feel in conversations I've had with administrative lawyers trying to grapple with what's happening in the copyright area, there is, just as I said, like thinking about the sort of normative weight of international law, there might be something specific to copyright that will affect the way that we think about the issues. I think the same thing happens here. There's something specific about the background, the role, and the organization and operation of the Copyright Board that has affected, I think, the sense of copyright lawyers and others who work in the field as to the amount of deference that's owed, and also the scope really of the decision-making capacities or mandates of the board. And I think where the board has, and it's not its fault, like when you're tasked with assessing the economic value of an activity, you can't parse that necessarily from the question about what is the part of the activity that triggers the right and what is the scope of the right, and trying to assess what economic value is attributed to it. But there's a difference between the tariff setting expertise and the interpretation of copyright interests and rights, the scope of those rights, what triggers them, the nature of users' rights and the public interest that's at play in the copyright system. And I think it is fair to say, and the sort of judicial review of Copyright Board decisions has demonstrated that when the board is really involved in assessing or in determining whether there's an infringement, the scope of that infringement, whether there's an exception that applies, that it tends to get itself into some hot water, and then those decisions get overturned on judicial review frequently. For my own part, I think that the expertise of the board, that the specialization of the board that might be owed deference relates to that valuation and tariff setting, which is, no small feat. Like that, to me, it's a big mandate, it's an important job, and it's an incredibly hard task. But when it comes to the substantive assessment and determination of the scope of competing rights and interests with a view to the copyright balance and the objectives of the Copyright Act, to my mind, that is the role of the courts, and rightly so.
Thank you very much for that. That question was from Aria Katz, Professor Katz from the University of Toronto. On the same theme, Howard asks, and Jeremy, I think you can give your views. Professor Craig has just given some insight into this, but Howard's question is, what basis is there to assume that the board or even its staff have any particular expertise in interpreting the Copyright Act or international law? A pointed question. What do you think, Jeremy?
Well, I think institutionally there's very little basis for that presumption, but individually there's extensive basis. If you look at an institution in the way that its composition is mandated by the Copyright Act, then yeah, all you need is a retired judge, and then there you go. But if you look at the individuals who have served as board members and as board staff, in many instances for years or decades, there is certainly an accumulated expertise. Now, I think the more difficult question is that a good or a bad thing? Sometimes you might need to step back and see the forest for the trees. And then I think just to foreshadow Jerry's question coming up, indeed, there tends to be a greater legal undertone or legal vibe, as international legal vibe, as Justice Stratus called it, than an economic vibe. The economic analysis does seem to be, I would not call it ad hoc, but more variable.
All right. So Jerry, the question here is the board's function is primarily one of economic rate setting, yet it has generally failed to establish and reference its decisions on economic principles. Instead, it has tended to deploy extensive legal analysis and references in its decisions at the expense of rigorous economic rate setting principles. Is this a flaw derived from the board appointment requirements, e.g. the chair must be from the judiciary and members tend to be lawyers? Professor De Beer has commented on this. I mean, I would say that, and this goes back to Professor Katz's question as well. If you go back to 1979, just before the era when Canadian courts began to defer to administrative decision makers, first labor tribunals and now all decision makers, presumptively at least. If you go back to that period, then there was a tendency to distinguish questions of law from questions of fact, policy, and discretion. And in that era, it's not at all surprising to see references in judicial decisions to the legal analysis in a body like the Copyright Board being incidental to its primary economic function. But one of the things which has happened since then is that that divide between law, policy, fact, and discretion really has broken down. And if you look at Vavilov, say, in its discussion of reasonableness review, that hard and fast distinction between law and discretion, which you find in many legal systems and many common law legal systems, it just doesn't feature. And so what may have happened is that the tides of administrative law have dragged the board from a purely economic and rate setting function to a function where everyone expects that the Copyright Board's views on questions of law are going to be intertwined with economic and policy and international law considerations. And if the Copyright Board isn't forthright in addressing those higher level questions and demonstrating how the interpretation of the Copyright Act is actually suffused by these policy considerations, it can get into trouble. That's not to say that the Copyright Board can just do a freestanding policy analysis in its reasons. As Justice Stratis says, you have to look at the text, context, and purpose of the statute. And I think you need to, the board needs to look at text, context, and purpose, and in doing so, demonstrate how these other considerations come into play. Not an easy task, I don't think. Professor Craig, Professor De Beer, any particular further response to that observation or comment of mine, and Jerry's particular question about?
Yeah, I might just add, because when I'm talking about this, you know, the specialization of the board and their expertise being in the economic active rate setting, you know, if that is the case, then I think that the question is very well placed. So if that is the challenge, then let's get into those economic questions about how those values are actually determined and how we could add to that how those tariffs are ultimately distributed, and the Copyright Board could take a much more active role, I think, in examining and following through on the collective management of copyright interests and the collection of royalties and distribution of royalties to members and so forth. I think it should be more active in that regard when it comes to looking at the collectives and their transparency and kind of following the money, if you will. And I think that it would be the right thing to build up the expertise and to focus upon that as a real contribution of the board to the operation of the copyright system, and to leave the determination, interpretation of the scope of rights and interests to the courts, to the extent that is possible. And I just would note that there's been a lot of movement to suggest that some of those changes are needed or might be desirable. Within the Copyright Board, we saw some amendments in 2018 implemented earlier in 2019 to try to sort of improve the processes of the board in particular, and to add some more resources and some more personnel. And I think those were well-meaning, and I think we don't yet know whether they have had the desired impact or whether more needs to be done. But I would note that the Copyright Act review of the INDU committee as well pointed to the slew of testimony that it received about the operation of the Copyright Board, complaints about not just a lack of sort of resources or questions about its authority, but also the sort of struggles to implement some of the exceptions that were added in 2012, and a struggle to issue decisions that were not overturned on judicial review, and also the procedural problems with regard to the timing of these decisions, which has been incredibly problematic, with decisions often taking years and tariffs being applied retroactively. And so I think there's a lot of work to be done to really maybe improve the contribution that the Copyright Board is making to Canada's copyright system. I think there are still some very well-placed concerns about that, and we should maybe turn our attention to those issues, and again let the court focus on interpreting the rights and defences in the Act.
On that general theme, Jeremy, if the copyright boards, we're talking about the raison d'être of the copyright board, if its tariffs aren't mandatory, as the Federal Court of Appeal held in the York University case, I think I'm right in saying it's 2020 FCA 77. What's the point of the copyright board if if we're doubtful about its role, if people are doubtful about its role in legal interpretation, and it should be doing economic analysis and rate setting, but those rates that it sets are not mandatory. What future for the copyright board?
Well, I think the board has a very important role to play in guarding against abuses of market power and ensuring that there are reasonable rates available should users wish to take advantage of that. I think the board also has an incredibly important role in facilitating efficient markets by promoting transparency so that users know what prices other users are paying. I don't know to what extent, at least under the current legislative regime, the board can get into a real supervisory function, certainly not a certification function, but possibly not a supervisory function over the collective administration of copyright generally. But there are other tools at the board's disposal which have not been used historically that the board can look at leveraging to help facilitate transparent, fair markets. And I think that in the right circumstances, the board can also provide a valuable service in facilitating negotiated agreements. And that sometimes the point of a tariff proposal and a process for objections and a long lead time up to a hearing is to create the conditions necessary for a voluntary agreement between parties. We've seen that happen many times. And so just because the board isn't issuing a decision or isn't issuing a decision immediately doesn't mean that things aren't happening behind the scenes and that there is not a valuable contribution to supporting a functioning market. On the issue of the sort of legal and economic roles, I think you asked earlier a question, Paul, about what the what's the future of 2.4, 1.1? What does it mean? And here I think I can give you an example of how these roles, the legal and the economic role, are really quite fused. So we know this much, that the communication right includes the making available. The board was reluctant to suggest that those two acts merge to create a single act. Justice Stratis, no doubt, in my opinion, was correct when he looked at it through the other end of the telescope to say there's actually no basis for disaggregating these two steps. So there's no question about merging them. It's just don't disaggregate them. But this leaves a very interesting economic question, a question about economic modeling. So there's no doubt that SOCAN has a right to be paid for the making available of works for streaming. It's included in the communication right includes that. But the current model is to collect royalties and to calculate royalty rates on the basis of the actual transmission. Well, if the tree falls in the forest and no one hears it, how do you get paid? So SOCAN would be entitled, in my view, to propose a fundamentally different structure for that tariff, where the royalty rate were calculated not on the transmission, but on the availability. So there's nothing stopping SOCAN from proposing a tariff based on essentially the inventory that the online streaming service wants to offer. And so that would require, I think, a radical rethinking of how the economic model works. And it might be something more like the radio tariffs, where it's a percentage of revenue or percentage of advertising revenue. or it could be some sort of a hybrid or a combination. Similarly, the question is now going to come up, where does this leave collective societies or individual rights owners who own reproduction rights in musical works or in sound recordings? Are they entitled to be compensated for the making available for downloads of those reproductions? And I think the answer is certainly yes, they are. It's not under the communication regime, and it may not even be under a tariff regime. So that question is going to have to be worked out. If, as my opinion is, Canada is not in violation of its WPPT or WCT treaty obligations, the question is, how are owners of reproduction rights going to get paid for the making available of their content for download? And that's a question that the board is going to have to grapple with. There's no way around it. And that's not the kind of question that you could just send up to the FCA in a reference. It's inextricable from the economic model and the rate setting function and the policy issues.
Well, thank you for that. I was about to say the questions have dried up, but then Howard has popped one back about well, if books are in the bookstore and nobody buys them, then the author doesn't get a royalty based on sales for books that aren't sold. That's a response to what we've been discussing.
But just in response to that specific question, there's no reason that authors and publishers cannot negotiate and retailers cannot negotiate royalty structures based on printing as opposed to sales. That's just that fact. That's just an artifact of the way that the royalty market has historically been structured. There's nothing predetermined about it.
I suppose I could pay, couldn't I, to put some copies of A Theory of Deference in Administrative Law in every bookshop in the country, I could certainly do that. I'm not sure that Chapters and Indigo would pay me for the privilege, but I could try. But certainly other more popular authors could plausibly do that. Professor Craig, any thoughts on that particular point?
No, I mean, well, yes. First of all, I'm sure your book is on every bookshelf anyway, Paul, so I wouldn't worry about it. But yeah, I think, you know, what Howard is pointing to, and it has been a concern with the move from traditional and analog markets into digital environments, is that unfortunately almost every transaction or action indeed with content in an online digital context involves a reproduction in a material form, albeit a digital form, of works. And so one of the big concerns that we've had with regard to the digital shift is the way in which copyright is implicated, you know, in almost every encounter with content in a way that it wasn't when you were strolling around a bookshop. And so, you know, I think we have to really, if we take the idea of technological neutrality seriously, we have to be alert to the way in which the old assumptions about what a copy is or what implicates a copyright interest might have dramatically different outcomes in the digital realm. And so far, I think we've been too inclined just to expand our old concepts into new environments and think that they're going to work there. And I think Howard's question really sheds some light on the fact that there is a difference and that reproduction rights are being implicated far more so because we're doing everything online. And if that doesn't, you know, unfortunately, the Supreme Court in the Sodrak case resisted Professor De Beer's excellent arguments regarding non-material copies and decided essentially that a copy is a copy. And I think that does mean, unfortunately, that there is a lack of technological neutrality when we're dealing with copies in the digital realm because the rights are being implicated more and more. But if we're concerned with the role of the Copyright Board, we might say that then the technological neutrality function, it belongs to them when it comes to evaluating like, what is the value of the copy that is being made. And to Jeremy's point, that can be assessed as part of the broader sort of economic landscape, looking at the nature of the transaction in the digital realm, and hopefully doing that with a view to the public interest and the policy goals of the copyright system, and with a view to maintaining the appropriate balance between owners' rights and users' rights, between protection and access in the online environment. I think you're muted, Paul.
A nearly perfect afternoon with the mute button, nearly foiled at the last minute. So we're coming up to 3:30 Eastern, and that's when things are going to come to a close. And I think Professor Craig and Professor De Beer, you've helped us to ventilate the issues in these fascinating cases very effectively, and I thank you, Carys and Jeremy. It's been a pleasure to have a discussion with you this afternoon, and I look forward to learning more about copyright law from you and others in the future. Florian, je te redonne le bâton.
Merci beaucoup, and thank you to the three of you for that amazing conversation. During the whole conversation, I was like, don't be a nerd, don't go on tech neutrality, don't go on the tech neutrality. But like, I feel we need at least 1 more hour just to discuss this and maybe some like ramification, maybe for like another workshop. Anyway, thank you again for everybody for joining us today. And for those who are like interested, I would invite you to join us for our next event tomorrow on AI, data, and equality in the Middle East with our colleague Nagla Risk. But so that's all for today. Thank you again for everybody for joining and for our 3 amazing panelists. Have a lovely day, everybody. Bye-bye.
If before we could sign off, I could just echo my appreciation that Professor Craig mentioned earlier for you, Florian and Paul, for organizing this. And I also wanted to acknowledge the great list of participants here. I could see many members of the copyright bar, the board, and the policy departments at ISED and Heritage. And so it's a daunting task to speak about these topics, and I appreciate everyone's attention and interest.
Perfect. Thank you again. Have a lovely day. Bye-bye.